Neither international law nor EU law operates in a normative vacuum within national legal systems. Their effectiveness always results from constitutional mechanism of reception. The relations between national law, international law, and EU law create together a multi-level legal order applicable to the state, in our case to the Republic of Poland. However, the systems coexist at various levels, different levels. There are two fundamental levels in the Constitution of Poland where the systems are organized. The level of validity. Here the Constitution incorporates ratified international agreements that were originally created outside of the national legislative procedure. We should emphasize clearly this is not a law enacted by Parliament, but a law negotiated by governments. Even ratification is only approval procedure without affecting on agreements content. I explained students that international agreements are the most undemocratic law that exists in the constitutional catalogue of sources of law. And the second level is level of applying. Here other external sources of international law can be applied by states organ as norms derived from other foreign systems, but within the limits and under the Constitution set under the conditions set by the Constitution. By the way, special treatment here is related to the EU regulations. Consequently, it is the Polish Constitution that organizes functioning of that multi-system legal order. The legal multi-system order constructed in that way is in Poland guarded by the guardians of the constitutional system. They are the Constitutional Tribunal, the Supreme Court, and the administrative judiciary. Their protective role is realized on different legal levels, on various legal fronts. Constitutional Tribunal control the hierarchical compliance of act of law indicated by Constitution, also international. And Supreme Court and administrative judiciary control the application of the law. These institutional competences historically shaped before EU accession, to date, Poland's EU accession, today conflict with the evolving judicial practice of international tribunals. An analysis of the Polish constitutional orders leads to the conclusion that the model of relations with international and EU law is based on the principle of favoring external obligations while maintaining the primacy of the Constitution. But constitutional openness to external law is neither unconditional nor automatic. It is systematically conditioned and limited by 1. The principle of constitutional sovereignty, 2. The democratic legitimacy of public authority, and 3. By the primacy of the Constitution as an act expressing the will of the sovereign. From this perspective, the Constitution is not an obstacle to system integration, but a condition for its legality and legitimacy. Constitutional practice in Poland demonstrates that a particular danger arises in situation where EU law or the case law of international courts is applied selectively, disregarding its actual normative content, scope of application, or conditions of implementation. In the era of the European Convention on Human Rights, the high constitutional position of the Convention as a ratified international agreement and the possibility to apply it, it is of course at least disputable possibility, raise practical challenges regarding the impact of European Court of Human Rights case law on national constitutional institutions. Two types of threats exist here. One, it is an expensive interpretation of the Constitution, leading to interference in areas beyond the European Court of human rights competence, and 2, the domestic practice of state authorities seeking legitimacy in the European Convention on Human Rights for actions taken contrary to constitutional principles. In such situations, the task of state authorities is to protect constitutional public order, primarily by seeking legislative and practical solutions that reconcile the Convention's obligation with the Constitution. And if this is not possible, through decision of an international law nature, which the Constitution does not preclude. In the era of EU law, the key tension emerges between the principle of primacy and the obligation to interpret EU law in a pro-EU manner. There is a growing tendency for the Court of Justice of the European Union to exceed the boundaries of interpretation, equipping treaty provisions with legal substance and entering into areas traditionally and legally reserved for the member states. A set of threshold criteria can be identified to test the constitutional permissibility of external law influence. In practice, these criteria can take the form of control questions. First, is there an unambiguous constitutional basis for the indicated effect? That is about validity, direct application, priority of application, or manner of performance of the obligation. 2, does the action fall within the scope of delegated powers in the case of the EU and does not violate constitutionally reserved constitutional elements? 3, is the effect not achieved by disregarding constitutional procedures? And 4, is the instrument used truly binding and has its content been reproduced fairly and in full context? A negative answer to any of these questions indicates a high risk of instrumentalization of external law. European constitutional system do not follow a uniform model of relationship with external law. This variation concerns the normative techniques adopted at the constitutional level and at judicial practice of constitutional or supreme courts. However, it exists an important common element that can be considered in European minimum standard. It is the rejection of automatism in the relationship between the constitutional and external law. In every country, regardless of whether a monist, dualist, or hybrid model of relation between legal systems is adopted, it is the Constitution and no one else that create conditions for functioning of norms stemming from external legal systems. This means that the Constitution is always the point of reference for the validity, application, and enforcement of norms coming from outside the national legal system. The possible differences are mainly on 3 levels. Firstly, the scope and intensity of constitutional examination of external law, from solutions allowing for broad ultra-vires control and constitutional identity control, as in Germany and Italy, to more restrained models limited to indirect or functional scrutiny. Secondly, the importance of constitutional identity doctrines, which in some states act as a workable boundary instrument, this constitutional identity review, and in others are rather declarative or interpretative. And thirdly, the role of constitutional courts in managing systemic conflicts, from an active boundary guardian model of the constitutional order to a mediation model based on judicial dialogue and the application of pro-European interpretation. However, this variation does not weaken the general conclusion or conclusions, but strengthens them. A comparative analysis of European legal system clearly shows that the commonality of the constitutional orders of the EU states does not imply their fusion into a single normative order, but is based on the mutual recognition of boundaries. The foundation of this commonality remains openness to external law, but not its primacy. In this sense, the European model of the relationship between the constitutional and external law is no one of hierarchical subordination, but of a dynamic balance between integration and international law and the preservation of the constitutional identity of states. Effective management of conflicts of legal system requires institutional and doctrinal dialogue rather than an ad hoc escalation strategy. This applies both to the relationship of national courts with international courts and to the relationship between national authorities. In this respect, it would be useful to treat an interpretation that is friendly to EU and to international law as a principle, but not absolute. This leads to a blurring of responsibility for decisions made in the name of external law. There is often no clear answer to the question of which authority and on what basis bears political and constitutional responsibility for the consequences of the collision. This makes it necessary to consider one clear attribution of responsibility for choosing how to implement international obligations, and to avoiding shifting responsibility to necessity under EU law or being bound by an international judgment. And 3, strengthening the role of Parliament in decisions of the systemic effects of integration. To counteract this, it would be appropriate to adopt the principle that 1. No political objective, even declared as protecting the rule of law or repairing the state, justifies action taken outside the constitutional framework. And 2. The Constitution remains a common point of reference even in situations of deep political dispute. And 3. EU law and international law should reinforce the constitutional order, not replace it as a source of legality and legitimacy. The use of the use of EU law and international law as a tool for circumventing constitutional mechanism of legality and legitimacy of power threats both to the rule of law and to the very idea of European integration, which loses its democratic basis. External law can only strengthen the Constitution if it acts within the Constitution, never instead of it. Thank you.